Okay, and a huge welcome to the next Your Employment webinar in the series, providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are, of course, Jones Chase, a firm of specialist employment lawyers, and we act for a number of companies from PLCs all the way through to startups and also some fantastic individuals as well. And we have a very high success rate of looking after those that we represent, which is north of 95%. And we are, of course, delighted to have you with us. And I would just like to quickly introduce the team who will be speaking to you today. So we've got one of the firm's senior associates, Harriet Botel.
Hi, everyone.
And we've got the firm's paralegal, Dominic Lyons.
Hi, everyone.
And I'm going to admit this, so we had a fourth member of the team lined up to speak, who was Zainab Hakim. Unfortunately, her laptop decided to cease functioning, and we had the computers not working sign pop literally 15 minutes ago. So Zainab's sort of desperately dealing with our IT team, desperately trying to get back online so she can do her section. So we are going to have to just wing it a little bit. Me and Harriet will briefly cover Zainab's section, and then fingers crossed she'll be able to join us by the end of the webinar. If not, we can send them a quick bulletin after the webinar if there's enough interest in that. Okay, so I apologize, but yeah, so Zainab's laptop stopped working 15 minutes ago, which has never happened to us before. So touch wood, the three laptops remaining will all carry on working. Okay, so moving quickly on. In terms of format for the webinar, if you want to ask us questions, please do so. You can use the Q&A box, and importantly, hit the anonymous button if you want to do so anonymously. If you don't mind your name being displayed, you can use the chat box, which we'll be keeping an eye on too. And if you want the rest of the attendees to see what you're saying, which is actually quite helpful to keep the conversation flowing, please use the drop-down box and select all panelists and attendees, which means people can see what you're saying, which is good. If you want to speak live, please write this in the Q&A box, and either myself or one of the others will unmute you. I should add that we are recording the webinar to allow us to distribute the webinar to those that couldn't make it at this time. So please bear that in mind if you're asking questions and you want to do that anonymously. I should emphasize that the points that we're covering today are not formal legal advice, and so much depends on the facts of the case. And sometimes the approach that you take in one case is not the approach that you would take in another. So therefore, please do not rely upon this webinar for legal advice, and do get in touch with us instead. And the context and the facts of each specific case are very important. And as a quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 24th of February 2022. Things are changing very quickly as ever, so do drop us a line if you have any further questions. And we do appreciate that everyone's time is precious, and we're definitely going to finish at 5 p.m. today, if not before, particularly because Zainab's laptop's decided to stop working. We may be a little bit early, but we'll see. And lastly, we do like helping people. So if you have any further questions or any issues you'd like to discuss with us, or anybody else that you think would benefit from working with us, we do love referrals. So please definitely send people through to us. And we act for companies as well as individuals as well, like I just said. Okay, so this is a special webinar with a focus on the important topic of flexible working, and we're going to take a more in-depth and forensic look at this very complicated area of the law. And we're doing this because, of course, there's been a huge shift in how people work due to the pandemic, and therefore it's actually been reported there's been a 52% increase in flexible working claims at the Employment Tribunal. On top of that, it's been reported that 90% of employees want access to flexible working options. And this is quite surprising, but nice to know in some respects, that job adverts which offer flexible working increase applications by 30% these days. And that's been reported by the Government's Equalities Office. So yeah, there's been a growing interest in flexible working applications, also submitted by male employees since the pandemic, whereas prior to 2020, the majority of flexible working applications were submitted by female workers, apparently. Okay, so plenty to go through all on the subject of flexible working. The first up is Dominic, who's going to quickly run through the basics of the statutory flexible working regime and a few other things, such as what you should include in your flexible working policy. So over to you, Dominic.
Thank you, Dean. So as mentioned, I will be providing an overview on flexible working and the law as it currently stands. So first of all, looking at who can exercise the statutory right to request flexible working. So in order to make a statutory request for flexible working, the following eligibility criteria do apply. Firstly, a statutory request can only be made by an employee. And secondly, the employee must have 26 weeks continuous employment at the date the request is made. although this may be subject to change, as I will discuss later in my talk. Thirdly, only one request may be made under the statutory scheme in any 12-month period. And finally, requests cannot be made by agency workers, with the exception of those returning to work from a period of parental leave. So now looking at these individually in a bit more detail. Firstly, a request can only be made by an employee. So only employees are able to take advantage of the statutory right. As a reminder, an employee is defined under the Employment Rights Act of 1996 as an individual who has entered into or works under, or where the employment has ceased, worked under a contract of employment. So subject to meeting the other criteria, the right also does apply to fixed term employees and those employees who already work under a flexible work pattern. The right does not apply to self-employed contractors, consultants, or agency workers. Secondly, to qualify to make a flexible working request, an employee must have at least 26 weeks continuous employment by the date on which they make the request. The usual rules establishing continuity of service do apply, so that service with an associated employer or service prior to a TUPE transfer, for example, will be included. Thirdly, an employee who can make one request under the statutory regime in any 12-month period, with the time being counted from the date on which they make their request. Although the circumstances of either the employee or the employer's business may change, the statutory right to request flexible working does not include any mechanism for dealing with a further request within the 12-month period. There is, however, nothing to prevent an employee making additional informal requests. So, as I said, the additional informal requests wouldn't create any permanent contractual change, although this in itself does have its risks. While the employer will not be obliged to follow the statutory procedure in response to an informal request, a refusal without appropriate consideration could give rise to claims outside the statutory flexible working scheme, for example, a claim for discrimination, and this will be covered further in our talk as well. So finally, looking at those who are excluded from making the request. So firstly, agency workers are specifically excluded from eligibility from the statutory right to request flexible working, with the exception, as I mentioned, of those returning to work from a period of parental leave under the regulations. Additionally, employee shareholders, with the exception of an application made within 14 days of the day on which the employee shareholder returns to work from a period of parental leave, they are excluded from being able to make a statutory request for flexible working. And finally, looking at it from the perspective of armed forces, under the Employment Rights Act, the section concerning flexible working does not apply to members of the armed forces. However, in February 2018, the Armed Forces Act 2018 received royal assent and it came into force with effect from the 1st of April 2019. This act enables regular members of the armed forces to request to work part-time for a temporary period and to temporarily limit geographical separation from their home base. So now looking at the proposal for reforms. So as previously mentioned, there are proposals for reform which may see changes to some of the law that I've just previously mentioned. The proposals included a number of measures to broaden the scope of the right while retaining the basic system involving a conversation between an employer and an employee about how to balance work requirements and the individual's needs. The main change would be making the right a day one right, as many of you may be aware, removing the requirement for 26 weeks qualifying service. So the consultation was published in September 2021, and it sets out 5 proposals for reshaping the existing framework. Firstly, making the request for a flexible working a day one right, as just mentioned. Secondly, making changes, if necessary, to the 8 business reasons for refusing a request to work flexibly. Thirdly, requiring the employer to suggest alternatives to the arrangements suggested by the employee. Fourthly, changing the administrative process underpinning the right to request flexible working. And finally, raising awareness of the existing right of employees to request a temporary flexible working arrangement. And it's likely that any changes to the flexible working regime will be included in the forthcoming employment bill. And this is said to be introduced when parliamentary time allows, once the post-pandemic needs of businesses and workers are more firmly established. So now looking at how an employer should deal with a flexible working request. So an employer who receives a flexible working request under the statutory scheme must, first of all, deal with it in a reasonable manner. Unfortunately, there's no statutory definition of what is dealing with this request in a reasonable manner, but Acas do make recommendations on how an employer should deal with an employee's request for flexible working. Examples do include talking with the employee as soon as possible after receiving their request, unless the employer intends to approve their request, therefore a meeting will not be necessary. Another example is ensuring that the discussion takes place in a private place where what is said will not be overheard by fellow employees. As an employer, you must notify the employee of your decision within the 3-month decision period, unless it is extended by agreement. There is no requirement in the legislation for the agreement to extend the decision period to be recorded in writing, but this would be good practice. An example of this is in the case of Walsh and Network Rail Infrastructure from 2020. The Employment Appeal Tribunal held that the statutory scheme for flexible working requests is clear that there must be an agreement to extend the decision period. In this case, an employment tribunal had held that the decision period had been implicitly extended by the parties, where they arranged an appeal hearing to take place after the end of the 3-month period, but without addressing the extension of the decision period itself explicitly. So an agreement to an appeal on a specific date did not necessarily involve an agreement to extend the decision period. Furthermore, specific agreement to the period of the extension is needed to avoid confusion on whether the extension is to the appeal date or for a further period for the appeal to be determined. So an employee's request is taken to be made on the day in which it is received, but that ultimately depends on the form it is received. So where there is a system in place, potentially an electronic one, and there's a specified electronic form to be used, and potentially even an email address to which the request can be sent, the request is taken to be received on the day of the transmission. But if the request is required to be sent by post, it is received on the day that it would have been delivered in the ordinary course of post. And finally, if it is delivered personally, it is received on the day of delivery. So a request may only be refused on eligibility grounds for one or more of the 8 prescribed reasons. And this will be covered in more detail by Zainab, who has just joined, fortunately. So we'll get into that in more detail. The Acas guidance does also suggest, following the receipt of a flexible working request, it is important for employers to do the following. So firstly, ask for the request in writing if that's not already been done. Consider the request fairly. Discuss it with the employee. Look at the other options if the request is not possible. Make a decision based on fact, not personal opinion. Only turn down the request if there's a valid business reason. Give the employee a decision within 3 months of receiving the request, unless this has been extended by agreement, as previously mentioned, and allow the employees to be accompanied at a meeting to discuss a flexible working request, such as by a co-worker or a trade union representative. The Acas guidance also recommends that employers follow the Acas code and their own flexible working policy, if applicable. So finally, looking at that in a bit more detail, the flexible working policy part, as an employer, what can you do prior to receiving any flexible working requests? Well, employers who are able to accommodate flexible working requests have generally reported favourable results in terms of staff retention and morale. Of course, this approach is likely to be easier for larger employers with flexible staffing requirements. The Acas guidance suggested that a flexible working policy should explain how employees should make their request, including who the request should be sent to, what should be covered by the application, and potentially how it should be sent, as mentioned previously, the form of electronic communication or by post. Include a statement to the effect that the employer will consider the request and will only reject it for one of the 8 business reasons, and state who can accompany the employee at any meeting regarding the request. Explain what arrangements there are for appeals, and set out time limits on dealing with the requests. That is just guidance, and it ultimately is not going to be able to cover all business needs. And we do recommend that it should be tailored to each individual business needs. It is advisable for it to be made so it is commercially viable and suitable for your company. Additionally, it should be regularly updated to keep current with changing law and business practices. And here at Jones Chase, as a firm, we can help you or your contacts with dealing with flexible working requests and implementing an appropriate flexible working policy to help streamline your business. And that's all from me.
That's great. Thanks so much, Dom. I'm just going to say to everyone as well that there's literally so much ground that you covered there that has been the subject of so many different employment tribunal cases. So all the guidance that you mentioned, so many individual parts that have been litigated, hence we've got to where we are. So a recording of this webinar will be available on our YouTube channel. And if people are really interested, you can go back to the sort of Dom's 10 or 15-minute section. There was just so many important legal points in there, too many to list now. But as Dominic's mentioned as well, we can of course help with flexible working applications and to get your policy really commercially suited to your business as well. We are short on time today. There's so much to cover. So I'm so glad that Zainab has got a computer working again and she's share with us. So handing over quickly to Zainab, who's going to discuss the grounds for refusing a request. Over to you, Zainab.
Yes, I had a very panicky 15 minutes or so I'm pleased to be here. So yeah, I'm going to be talking about the circumstances on which you can essentially refuse a flexible working request and what potential risks there are with that. What's important to bear in mind, I think, throughout this discussion about flexible working is that you need to consider discrimination claims and other claims that an employee may have when you consider refusing a request. And Harriet's going to be talking about discrimination claims in a bit more detail. Another thing to consider is that we are in a very different place now than we were 2 years ago when individuals were making flexible working requests. There's been an evidential swing the other way, if you will. So it's really important that you have a clear business case for rejecting a request, and that's what we do best, making sure that you do have a clear business case and stress testing your reasons for refusing a request. So we can definitely help you in that regard. So a request can only really be refused on eligibility grounds or for one of the prescribed statutory reasons. You can, as I've said, turn down a flexible working request if there's a valid business reason to do so. And it's important to make sure that your decision is based on facts. Any refusal or rejection should be done in writing. But before you even get to the refusal or the rejection, it's important to consider how you deal with requests, right? So you need to demonstrate a serious consideration of the request. You should look at the new working pattern that's been requested before meeting with an employee, consider potential business issues, consider ways to mitigate those business issues, which could involve discussing the proposals with employees, managers, or other colleagues as well. And if the suggestion by the employee is not going to work, the request is not going to work, maybe think of alternative ways in which you could meet the employee's objectives as well. If you show up to a meeting showing that you've actually considered the request seriously, it's more likely that the employee is going to feel that you have approached the request in a genuine way and is more likely to engage in discussions about alternatives. So it will ultimately result in a more productive discussion with your employees. So start from a positive perspective and then seek to overcome potential issues, right? So onto the rejection of any application on eligibility grounds. So a request can be refused because it doesn't meet the statutory requirements. This could be if an employee fails to meet eligibility criteria, but you should still consider whether the application merits consideration anyway. If an application is to be rejected, then we advise that the rejection is on one of the statutory grounds following serious consideration, rather than rejecting the application because the employee doesn't fit the criteria for the statutory request. Given that the employee may have alternative statutory protection and be able to bring a claim that would be far more expensive for you to deal with. An application could also technically be rejected on technical flaws. I say technically because it's not really a good idea to do so. The case law does suggest that if an employee hasn't made the application properly, for example, if they fail to explain the effects of the proposal on the business or how the effects could be accommodated, you could reject the application on that basis. But again, you want to consider costly discrimination claims or constructive dismissal claims. If a request is technically flawed, it would be better to explain that to an employee and suggest that they resubmit a valid request. The 12 months which they have to bring only one request doesn't apply when the initial request is technically invalid. It is reasonable for employees to expect some support from employers in the process, and an outright rejection on a technical point just won't particularly help you. It won't be looked upon favourably by the tribunal. So now on to the actual reasons why you can reject or refuse a request, one of the prescribed reasons. So the legislation recognises that you might have a legitimate business reason to do so. There's 8 specific grounds on which you can reject. There is some helpful Acas guidance on business reasons for refusing a request. Rather unhelpfully, though, it has been archived by Acas, but you can still find it online, and it sets out some examples kind of in respect of the business reasons, which I'll pick up on when I'm going through those 8 reasons on which you can reject. So the actual legislation in this regard suggests that the test is subjective on the part of the employer, and so you can, if you consider that one or more of the grounds applies, then the test is essentially satisfied, and the test doesn't, on the face of it, import any question of reasonableness into the judgment. There's also no statutory requirement to include a sufficient explanation for the employee, but again, we think it would be good to do so. It would help your position, and it would ultimately help the employee as well if they're trying to appeal, and it's a bit harder for them to do so because you have provided sufficient explanation. So onto the 8 grounds. The first one is the burden of additional costs. So you want to look at less obvious savings, like, for example, the reduction in overheads from home working, which lots of people have seen since the pandemic. The second one is detrimental effect on the ability to meet customer demand. So you might here consider using a trial period to assess the impact on the business. So just a brief segue into trial periods, because they are important. The legislation doesn't provide for or regulate trial periods, but there's nothing to prevent you from agreeing to one. So a trial is where you can be used where you're unsure how the change will work in practice, or you might want to use a trial period instead of rejecting a request outright, where you don't know if it's sustainable or what the impact would be on the business. So what's important to consider with trial periods is that employees could use trial periods tactically. They could suggest a trial period, you say, okay, yeah, we'll try a trial period, and then they perform really well during the trial period. It becomes much more difficult for you to reject the request. However, an employee can't insist on a trial period, right? It's not within the legislation. So if you have considered the alternative risks, if the employee could bring a claim and you consider that on balance there is a low risk, ultimately it would be best to reject the idea of a trial period. So just by way of one of the examples that Acas has in their guidance, it relates to an employee who's making an application to work compressed hours. He wants to do 1 day of study in each week, and that's a Thursday. The employer is concerned that the employee won't be available to deal with kind of pressing time-dependent issues that crop up on that Thursday where he's off doing his course. Okay, they're worried about losing sales or attracting complaints because he's not there and he's working longer hours on the other days. Ultimately, they like the employee, they want to keep the employee, so they consider a 3-month trial period to consider whether the request will work. So it transpires, rather than complain, actually customers are happy. This individual is available out of working hours for the 4 days of the week that he does work. The office secretary is able to manage things in his absence on that Thursday, and he's available by phone, albeit not all the time, but he is available by phone if there is an urgent issues that kind of arise. So after the successful trial, they agree to the compressed hours. Okay, so that's just one of the really helpful examples that Acas provides in their archived guidance. The third grounds on which you can reject is the inability to reorganize work amongst existing staff. So you'd want to talk to your team about reorganization before coming to a decision. The fourth one is the inability to recruit additional staff. You might want to consider recruiting people against the potential cost of losing an existing staff member if you weren't to allow the request. The fifth is the detrimental impact on quality. So you don't want to lose sight of other employees' skills. Obviously it's about one employee in particular when you're considering their request, but how can the other staff kind of support in order to facilitate a flexible working application? The sixth is detrimental impact on performance. So you want to consider the impact of the individual, the team, the whole organization. The seventh is the insufficiency of work during periods where an employee may be proposing to work. So an example that Acas uses is for an individual who works in a call center where he's dealing with calls from the US. He wants to start at 6 a.m. every day. The employer looks at the call patterns and decides that there's inadequate demand from 6 a.m. till 9 a.m. in the morning, UK time, and so decides that actually the request wouldn't work because they need someone there to field the calls during peak time, so they turn the request down. The final and the eighth reason on which you can turn down a flexible working request, is if there's a planned structural change within the business. And it's important, if there is, that it's good practice to share that with the workforce, so it will help them be able to see why flexible working wouldn't work. I am nearly there. I'm now onto the risks. So potential claims. Now, claims under the statutory scheme actually lack teeth. I'm sure you're aware that the tribunals can only kind of look at an employer's decision to a limited extent, and they can only make really low awards of compensation. We're looking at 8 weeks, right? What's more likely is that an employee will bring a claim for discrimination or constructive dismissal, which are much higher value claims, and then add this claim as a bolt-on to their larger claims. So in terms of the statutory scheme and the claim that can be brought in respect of that, it would be based on procedural failings by the employer, and there are 5 potential procedural failings, which include failing to deal with the application in a reasonable manner, rejecting the application for a reason other than statutory on statutory grounds, or rejecting the application based on incorrect facts. Like I've said, the tribunal doesn't question the commercial, shouldn't be questioning the commercial rationale or business reason behind an employer's decision to refuse, and it can't substitute its own decision in there. Really, its role is restricted to reviewing the procedure followed, considering whether the request was taken seriously, considering whether the decision was based on correct facts, and considering whether the actual reason falls within a permitted ground. In terms of other potential claims, which Harriet's not going to cover, there's constructive dismissal. So constructive dismissal, I'm not going to bore you with all the details of it. That's not what we're here for today, but constructive dismissal occurs when an employer doesn't dismiss an employee, but the employee resigns because of a breach of contract by an employer. So there's various requirements which need to be met for that. But in the context of flexible working, it may be that the employee feels that the way in which an employer has conducted itself is likely to damage the relationship of trust and confidence between the employee and the employer and themselves, right? There are a few other claims. I'm going to talk very briefly about them. So unlawful detriment, the Employment Rights Act provides that an employee has the right not to suffer detriment short of dismissal if they've made a claim, if they've made an application for flexible working or proposed to make one, or if they brought proceedings against an employer regarding flexible working. And it's for the employer to show the ground on which the act or the failure to act was done. Okay. And lastly, automatic unfair dismissal. So the Employment Rights Act provides that it's automatically unfair to dismiss an employee if the reason or the principal reason for the dismissal is that, again, the employee made or proposed to make an application, or the employee brought proceedings against the employer under the flexible working legislation. And that is it for me.
Okay, thank you so much, Zainab. So glad that you managed to make the webinar last minute, which is great. And just to let everyone know, we are absolutely cramming a whole ton of legal content in you today. We are going, I know we're going very quickly, but we wanted to give you as much information as possible. So, so we've done the basics of the statutory regime with Dominic. Zainab's done refusal of requests and the risks associated with it. The other main part of this, or I should add as well, we've had 4 questions in prior to the webinar. I'll be dealing with all of those in my section. But before that, we've got Harriet, who's going to discuss about the complicated link between flexible working and discrimination. Over to you, Harriet.
Thank you, Dean. So yeah, I think I'm going to be really carrying on from where Zainab left off in terms of, obviously she mentioned several times that there can be other claims that employees can bring other than breach of the statutory procedure. So obviously you have some employees who may just have a claim for breach of the statutory procedure because there's no other potential discrimination claim they could bring. So that's possible, you may just have that claim. But other employees may have this further statutory protection, which, you know, as Zainab said, you always need to be mindful of what their reason for asking for flexible working is, and whether a rejection of that request could lead to a discrimination claim. And the kind of things we're thinking about are employees seeking to vary their working hours because they have childcare commitments, possibly on return from maternity leave. People may have religious requirements, such as not wanting to work on the Sabbath, or being allowed time off to pray or attend worship, or those who may be seeking adjustments because they're disabled. And I think in the context of discrimination claims, I would always advise that you consider carefully whether a role cannot be performed flexibly, and whether and how that belief is actually justifiable. Because I think, you know, there are plenty of claims where you know, the claim may have been not in breach of the statutory regime, but actually it's upheld as an indirect sex discrimination claim. And you have to go much, much further to defend a discrimination claim than you do a statutory claim. And as Zainab said, you know, the legislation governing the statutory right doesn't really, or offers in fact very little scope to examine the commercial rationale for your business reason, whereas in a claim for discrimination, particularly you know, indirect discrimination, the reason why the decision has been reached is absolutely fundamental to establishing whether the decision can be justified. So the tribunal is going to be performing a very different exercise when looking at a discrimination claim. And we find that many organisations have roles which they consider couldn't be performed on a flexible basis. And often this view doesn't actually survive the critical analysis, and may not be capable of being objectively justified if an indirect discrimination claim was brought. And as Zainab said, you know, that can be where we can help to really sort of look at what those reasons are and sort of stress test them. And I think it's important to consider whether this belief that this particular role can't be done flexibly, and whether that belief comes from a manager in the business, from HR, or from the CEO, that the role can't be performed on a flexible basis. You know, is that due to stereotypes? Is it due to some kind of prejudice, or is it genuine business need? But I think those questions really need to be asked. And cost may be an issue, but case law has acknowledged that employers will have to put up with a certain level of cost and inefficiency for the sake of improving family-friendly policies and practices. And if there is a particular role that simply wouldn't work on a flexible basis, then the rejection of a request could definitely be objectively justified. But case law seems to suggest that those circumstances might be unusual. So I think that the leaning from tribunals is very much that the burden is proof of definitely on the employer to objectively justify, but you really would need to work hard to persuade a tribunal that a rejection is justified. And what we're looking at here is whether or not the rejection of a request could put a particular group at a disadvantage, and if so, whether that disadvantage can be objectively justified. And as you may know, objective justification involves looking at whether the refusal meets a legitimate aim and is proportionate. And I'm going to look at those in a little bit more detail, but really this requires the employer to show that there were no less discriminatory ways of achieving the aims that you're looking to achieve. And I think, as has been said already in the webinar, we find that, if an employee has received a clear and credible explanation for why their particular request can't be accepted, and they've looked at alternatives and they can't be found, they're much more likely to remain and engage a member of your workforce, less likely to challenge the decision by a discrimination claim, less likely to resign, potentially claim constructive dismissal, which can also be very costly. And I think just another sort of practical tip is to really try and ensure consistency when dealing with flexible working requests in terms of how you process them. And I think if you have a large organisation with a centralised HR function, HR should be involved in ensuring that these decisions are considered consistent and they're done consistently with any previous decisions. So you're aware, if you're going to make a decision which is inconsistent with previous decisions, that you know that, and that you're able to explain that inconsistency. For example, if the organisational capacity for flexible working has been reached, and to grant any further requests would undermine the business, that could be a valid reason. And particularly where the applicant is a different sex from those whose requests have previously been granted, or might be able to rely on some other discriminatory distinction between themselves. So it's important just to bear that in mind. So I now just want to quickly run through the different types of discrimination to have on your radar. The first one I'll talk about is sex discrimination. That's where most of the claims we see are based. So a woman whose request for flexible working is rejected may make a sex discrimination claim. As Zainab had said, it's very common for any breach of the statutory right to request flexible working to be accompanied by a claim of direct or indirect sex discrimination. You normally will get both of them together. So this has become a really effective remedy for women, indirect sex discrimination. And I think, obviously you get a lot of requests from people who are about to return from maternity leave. Need to consider that really carefully, and obviously be mindful of any additional risk of claims for maternity discrimination, which could also arise. You may have claims for direct or indirect discrimination being brought against you, and obviously both men and women can make requests to work flexibly under the statutory provisions. And I believe it's a case that many employers may tend to look more favourably on requests by women than those by men. And obviously this could expose you to claims of direct discrimination by men. That's something to bear in mind. So if the request to work flexibly isn't considered seriously because it comes from a man, when the same request made by a woman would have been properly considered, then a claim for direct sex discrimination from a man would succeed. And just one example in case law, which is quite interesting, case of Walkingshaw and John Martin Group, where a man who'd been denied the right to work part-time following his wife's maternity leave claimed direct discrimination because women in his firm were regularly allowed to work part-time. And apart from those actual comparators that he had of those other women, he was also entitled to compare his treatment with how a hypothetical female comparator in the same post as him, performing the same tasks, would have been treated. And the tribunal found that she was much more likely to have been granted the request than a man. And obviously this only works where a man can demonstrate that a woman's request would have been granted, or at least seriously considered. And if an employer would have denied everybody a request, then a claim for direct discrimination obviously isn't going to work. And just looking now at indirect sex discrimination, because this is the most common type of claim that we see arising from flexible working. And just a reminder, because indirect discrimination is a really complicated area of law, so just a quick reminder on how that works. So it's where an employer applies a provision, criterion or practice, often referred to as a PCP, and they apply that to all staff. So here we could say to all men and women, and this could be a requirement to work in the office 5 days a week, for example. However, that requirement puts, for example, women at a particular disadvantage, so a group disadvantage, and this may be due to their childcare commitments. It also puts the particular individual who's made the request at this disadvantage, because that's why she's asked for flexible working. And the important bit that we're going to look at now is that the employer can't justify this practice by showing it to be a proportionate means of achieving a legitimate aim, which we call objective justification. So looking at this objective justification, as I said, the burden of proof really is with the employer to demonstrate it. And what this means is that the ground that you choose for the rejection has to correspond to a real need on the part of the employer. And it's also got to be both appropriate and reasonably necessary to achieve this objective. So you need to first decide what your legitimate aim is. So this could be, for example, to maintain successful relations with customers. It just needs to be a real need of the business. This step is the relatively easy one, but you need to think about that. What are you trying to achieve? What's your aim? And then you have to show that the refusal is proportionate to this aim, and this can be much more difficult. And this involves the balancing act between the discriminatory effects of your practice. For example, you can't work from home, you have to work in the office 5 days a week. Balance that with the objective needs of the business, and the more negative the impact on the individual, the more weight there is on the employer to demonstrate its needs. And unlike the statutory regime claims, the tribunal itself is going to weigh up the needs of the business and make its own assessment, rather than relying on whether the employer's decision was within the band of the range of reasonable responses, as you'll be probably familiar with from unfair dismissal claims. So they're going to look at each business reason relied on in detail and consider what evidence the employer has supplied to sort of support those decisions. And if the employer has come up with problems in terms of, this is why we've rejected the request, a tribunal will expect an employer to deal with a certain amount of difficulty, a certain amount of inconvenience, and they will really probe as if it might have been possible to overcome an issue. Then the tribunal may not give that reason much weight. So they really will look at it in quite a lot of detail. And just as a reminder, compensation for discrimination is uncapped, and can also attract an award for injury to feelings. So I think taking advice at an early stage, right at the beginning, to really plan the response to the request and make sure it is as defensible as possible, can really pay dividends in avoiding expensive tribunal claims. And also, as I said earlier, if you're able to provide a well thought out, clear, credible response to an employee, you're more likely to retain them in the business and have a happier workforce. So it works on both sides. I'm conscious of time. Do a quick whiz through the other possible claims just to have on your radar when dealing with these requests. The next one is disability discrimination. And as you may know, the duty to make reasonable adjustments is unique to the protected characteristic of disability. And where that duty arises, you must effectively treat the disabled person more favourably than others in an attempt to reduce or remove that individual's disadvantage. And the EHRC Employment Statutory Code of Practice is really helpful in looking at what adjustments might be reasonable. They have a list of sort of non-exhaustive adjustments, and one of the adjustments is to alter a disabled person's working hours, and this could include allowing the person to work flexible hours, to enable them to have additional breaks to overcome fatigue arising from their disability, permit part-time working or different working hours to, for example, avoid the need to travel in the rush hour. And the employee may ask for these adjustments by making a request for flexible working. So if that request is refused, the employer may then be in breach of the duty to make reasonable adjustments, which could lead to a claim under the Equality Act. Bear in mind also religion or belief discrimination, which I referred to at the beginning. An employee may make a request for flexible working, perhaps to change the days in which they work or their working hours to accommodate their religious beliefs and requirements. And if you reject their request and they have those reasons, then this could result in a claim for indirect religion or belief discrimination. And again, the EHRC code is really helpful and gives some examples. And they say that manifestations of a religion or belief could include treating certain days for worship or rest, following a certain dress code, following a particular diet, carrying out or avoiding certain practices. So if you have a particular provision, criteria or practice which disadvantages an employee in this regard, again, it might be indirectly discriminatory. And lastly, in terms of obvious discrimination claims, there might be a risk for age discrimination claims, possibly where, for example, an employee makes a request to work from home. If the employer has a practice of only permitting the requests from older, more senior employees and rejecting requests from junior employees who tend to be younger, there could be an age discrimination issue there. And also potentially if an employee makes a flexible working request in order to care for an elderly parent, for example, those employees may tend to be of an older age group if their parents are older. So refusing a request could then lead to a claim for indirect age discrimination, as you may be disadvantaging an older group of workers. And Lastly, Zainab mentioned constructive dismissal, which again is obviously very important to bear in mind. And just I wanted to mention on that case law has held that rejection of a flexible working request, which did amount to indirect sex discrimination, was also a fundamental breach of contract, which did entitle the employee to resign and claim constructive dismissal. So depending on the reason that the employee is making their flexible working requests, you may have a constructive dismissal claim as well as a discrimination claim. So there's lots to think about here in terms of getting all your ducks in a row right at the beginning, and really, I think, stress testing those reasons and thinking around all the possible ways of dealing with it. And that's, yeah, I shall hand back to Dean because I know that time is tight. So thank you.
Oh, that's great. And thanks so much, Harriet. And it's worth mentioning that a lot of the work that we do for our clients is getting in at the early stage and really, as you say, stress testing the defense to discrimination case if for business reasons, if requests for flexible working, they want to reject it for operational reasons. And it's building that body of evidence and working with our clients to make sure that they can, as safely as possible, reject the request. And we also try to manage the psychology of the individuals on the other side as well, who may be upset when it gets rejected. So it's about getting people to understand why you're doing it. It's important to avoid litigation, but obviously having the defense to discrimination cases in place before you dive into these processes is hugely important. And that's a lot of the work that the good legal work that we do. All our attendees have been very quiet today, no questions in the chapter Q&A box, which is very unusual, but that's fine. I'm just going to run on very quickly to my last section before we finish at 5 o'clock. And I'm going to be covering very quickly the final section, how flexible working relates to hybrid working, also home working, and the phenomenon that is known as the childcare disparity, and how can that be challenged. Okay, so to begin, it's probably best to do this by answering a question that's come through just prior to the webinar from Nicola. Hello, Nicola. And she's asked this, could somebody give a brief definition of the difference between flexible working and hybrid working? Yep, I can do that. And the answer is that hybrid working is essentially, I was thinking about this all day, by the way. It's one of these things, it seems relatively easy to describe in your head, but when you try to enunciate or try to get it out there, it's actually quite difficult. But in my view, hybrid working is essentially a subdivision of flexible working. Okay, so hybrid working or even hot desking is usually driven by the employer, whereas flexible working via the statutory regime is usually driven by the employee. Okay, and also the statutory flexible working regime only applies to employees, which is a technical point, whereas hot desking and hybrid working, that can apply to all members of the workforce, including workers, agency workers, consultants, freelancers, etc. But essentially, I think my view is that flexible working is a much wider concept than hybrid working, and hybrid working only relates to changing the place of work, which is changed from the office of a normal workplace to allowing people to work from home. Whereas flexible working, of course, can involve a far greater number of changes being made, such as the changes to the number of hours being worked within the week, which are typically requested to be reduced by people or working part-time. Again, it's driven by the employee and not the employer. And people will want to change their hours for school runs, working later in the evenings, compressing a normal working week into 4 days. We've got a bulletin about that coming out soon. And other flexible working concepts are job sharing or term time working, flexi time, etc. And none of these relate to a change in the place of work. So hybrid working, as I've said, only relates to changing the place of work, which is driven usually by the employer wanting to make a global change to how the business operates. And flexible working, usually driven by the employee, can involve a whole wide range of changes. So moving on to the next topic, which is hot desking. And again, now is another good time to explore a question that's come through just prior to the webinar. This is from Mandy. So hi, Mandy. And Mandy said that she would be interested to think about the interplay between flexible working and hot desking on the basis that a more hybrid model of working, on the basis that with a more hybrid model of working, a company can operate in a similar space, which necessitates hot desking even, which is less desks than employees. So maintaining flexibility is also impacted if the expectation is for employees to be able to come and go without a plan. And yeah, just on this point, as we all know, hot desking involves sharing desks. And this is more of obviously a practical measure, and it really relates to how the employer decides to lay out its office. So you can still have hybrid working if you don't downsize your office and everyone's still got their own desks. But if you do go hybrid working and allow people to work from home, then you can downsize the office, which a number of people, particularly in central London, I hear are doing, a number of companies doing. And people are going to have to share desks, and that's really what hot desking is. It isn't a sort of part of the statutory mechanism. It doesn't have to be. It's driven by the employer because they're in charge of the office space, and not driven by the employee. And another sort of key difference with, I think, with going back to hybrid working, I should have mentioned earlier, flexible working, is that flexible working tends to involve a permanent change to terms and conditions, whereas hybrid working policies and all the ones that we do for our clients, we strongly recommend having the right to revoke the hybrid working arrangements at the employer's sort of whim or discretion. So it may not involve permanent arrangements. So again, if you need any help with your hybrid working policies, definitely let us know. We'd love to help you with that, and the flexible working policies as well. Lastly, for today, just want to discuss the childcare disparity, which is what Harriet's already mentioned, which was, I think, first upheld in the case of London Underground versus Edwards, which is where the judiciary are mindful of the fact that women typically have greater childcare responsibilities than men, and that can limit their ability to work certain hours or to change their patterns of work on short notice, or even to be office-based. And there's been plenty of cases since the Edwards decision where these principles have been recognised by the Employment Tribunal, and a number of indirect sex discrimination cases have succeeded. And I just thought it'd be useful to discuss this as well, because whilst the judiciary do take notice of the childcare disparity, it doesn't automatically mean that any refusal of a flexible working request submitted by a working mother, for example, immediately means that an indirect sex discrimination claim should succeed. Okay. And really, and as Harriet's already mentioned, it relates to a group of people being disadvantaged. So working mothers, because of their childcare obligations, are less likely to be able to work full-time generally, or to chop and change their hours of work at short notice. And what this comes down to is whether or not the group disadvantaged, it depends on the interrelationship between the general position resulting from the childcare disparity and the particular provision, criterion, or practice in question. And so that needs to be looked at. And it also depends on the fact of each case, okay? And there's a number of decisions that have come out, one of which, for example, is Sinclair Roche, R-O-C-H-E, and Templey versus Heard, H-E-A-R-D, 2004, and another case of Hacking and Patterson, and another versus Wilson, which is a 2009 decision, where employers have actually challenged the childcare disparity. And what they've said is that you need to look at evidence to see whether the provision, criterion, or practice of the PCP is actually putting the claimant in question at a disadvantage. And there's been a growing body of evidence coming out that particularly very high-paid female senior executives in high-flying jobs can essentially afford childcare. And so a lot of the older cases which are brought prior to the Equality Act were based on the fact that women had to work flexibly, not that they would like to or wished to. And what these cases have said is that you really need to look at the individual facts and case in question just to see whether the claimant in question is suffering a particular disadvantage. And if we're dealing with a very highly paid senior executive female working mother, then essentially she may be able to afford childcare. And what that means is that that disadvantage isn't there. And then you could look at the justification potentially as well for the employer imposing the PCP. So I thought I'd just mention these cases because sometimes even these very well-established principles are worth challenging. And if on the facts the claimant doesn't have enough grounds to say that there is a disadvantage, then employers could reject the request for flexible working. And I guess that's all for me. It's just maybe just to end on saying that never be nervous about challenging well-established principles. This is what we do as a law firm as well. And it really is about being fair to everyone, but that involves being fair to the business. And if the business really has a strong case to say, we simply cannot do this particular flexible working arrangement, and despite how dangerous the sex discrimination case may look, is that if you take time with good legal advice to unpick that, then you could actually get home with it as well. And there's also the floodgate argument, which is allowing a request for one person may result in multiple other people wanting it as well. So it is worth sometimes investing in really getting a good case together to block something that is genuinely a problem for the business. And if it isn't a problem for the business, then as the four of us have said today, it really should be allowed, because the tribunals will generally look at any job can be done flexibly unless the employer, I guess, proves otherwise. And we've got 3 minutes left. We have no questions coming in. Remarkably, we're going to finish on time. I didn't think that we would. Okay, well, thank you so much for joining us. As a quick reminder, the information we've covered today is accurate as of the 24th of February 2022. If anybody has any follow-up questions or needs any further legal advice, do let us know. Lastly, so we did have a quick question in from Paul about has there been any update in relation to the employment world from the government's recent announcements today regarding the COVID-19 pandemic. It's not a topic that we were covering today. However, there is guidance notes that the government have released, and I think it's labeled COVID-19 Response Living with COVID. So there is a publication. If anyone's interested, we can email a link to them, which is related to the current relaxation of the COVID-19 regulations, also the rules and requirements in place. So if anybody wants that, drop me a line at dean.jones@jonestx.com. We can send the link through to them. Not enough time to cover that today, unfortunately, but thank you for being with us. We do appreciate it. And we've got plenty of bulletins coming out as well, which will be on LinkedIn and email to everyone. So have a great rest of the day, and we look forward to catching up with all of you soon. Thank you. Take care and bye-bye.